And we are live. You're gone, Fred? Did you leave? Let me see here. Hey, thanks everyone for joining. Non-negotiable press. Hey, what's up, man? Thank you. Just waiting on a few more to show up. Charles, how's it going, man? Thanks for being here again. Just doing our weekly podcast, our weekly live podcast. Sorry about my name. What's up, man? That's a good screen name. Sorry about my name. How's it going, Fred?
Hey, good. How you doing?
I'm doing
How's
good.
your week been?
It's been all right. It's been busy, but all right.
Good.
Yours?
Working like a Hebrew slave, man. A lot of things happening. A lot of casework we've been reviewing, working on, and just trying to stay focused, I guess, is the best thing. Best thing I could say.
All right. All right. So we
But
were
all good. Crazy stuff
asked.
going on in Congress, too. I'm telling you what, I don't know if anybody's watching all the stuff that's going on about the Antifa folks. I'll just mention this and we'll move on. Antifa is now registered by the government. It's been proclaimed a domestic terrorist organization, and they are being treated as such, which I'm all for. I think everybody has to comply with the rule of law. But they found that some of these Antifa members, their parents, are elected senators and congressmen. Very interesting.
Surprising
They're
or
all
not?
for communism, huh?
Not surprising.
It's not surprising. It's actually so unsurprising. It's boring. It's like, yeah, whatever. Of course, we all knew this.
Yeah, we knew.
So, what are we going to do tonight?
So we went over the First Amendment last week, and we basically went over one of the elements in the First Amendment, which was freedom of speech. Um, right?
It's huge. Yeah, it applies
Yeah.
to a lot of different scenarios.
Which we
And I want to
can.
make a comment about that. Is when you look at the Constitution, people say, well, how do we go from the Constitution to actually getting uh, federal laws and statutes? Well, the way it works is that when situations come up and situations go before the courts, they have to look at a specific scenario and see how whatever happened is appears on the backdrop of the Constitution. So that's how statutes come up, and they say, oh well, like just because this is so topical now, someone is video recording the police, and uh, and they're a safe distance away, which means they're not in between the. There's no way the officer cannot go from his police car, which isn't his, the people's police car. He can't go from there to the person he's conducting a traffic stop on. But they're standing on the other side of the car's video recording. I just saw a video where somebody was on the other side of the car, was video recording, and a backup cop came in and arrested him because he wouldn't move back another 5 feet off the sidewalk to video record further away from where the interaction was taking place. Uh, Now that case is right now it's just been heard by the Montana State Supreme Court, and they're trying to decide whether or not he was okay to be standing where he was standing video recording. Of course, it's going to come back and say that the police were actually improperly detaining this person and arresting him because what he was doing was constitutionally protected. Now, if in fact the Montana State Supreme Court is stupid and say, oh no, despite what the first, the third, the fifth, the seventh, the ninth, the 11th, and the fourth circuits have all said that this is constitutionally protected conduct, which I think they're in the, aren't they in the 10th? I think they might be in the 10th. I have to look and see where Montana is. But anyway, whatever happens, it'll go straight to the U.S. Supreme Court, and the Supreme Court will rule on it if Montana gets it wrong. Because that's what happens. That's the next higher court. It goes from the state Supreme Courts to the U.S. Supreme Courts. So now this situation is going to be very interesting. But what the guy was doing was constitutionally protected. It's constitutionally protected speech. And how you look at that, if you look at the First Amendment, it says Congress shall make no law making an establishment of a religion or abridging the free exercise thereof, or the freedom of speech, or of the press, or the right of the people peaceably to assemble. And he's engaged in this constitutionally protected conduct, and the cops decide, well, that he wasn't, and they're saying that he failed to follow a lawful what? To shut up. They are holding his camera, which contains is that from Wade Lucero?
Oh no, yeah, James Freeman got arrested yesterday for telling the cop shut up when he told him to move back. He was in a public sidewalk recording, and he told him move back, and then he said shut up, and then he's like, I can arrest you now for telling me to shut up.
No, absolutely not.
And they did arrest.
That's Lewis versus City of New Orleans, which is I believe a U.S. Supreme Court ruling. When this lady was actually a passenger in a car that got pulled over, she was literally, pardon my French, was just bitching out that cop, calling him everything under the sun. And she got arrested. Well, okay, he moved 30 feet back. He was 30 feet away. Yeah, this is a clear First Amendment violation. He can get him, and direct this to James Freeman. If he wants some help with a federal lawsuit as a pro se, we're happy to help giving him some guidance and support, because he's got a rock solid case. And this is one thing I want to mention before we go too much further into this. A lot of people think that cops believe this, is that just because they say something, that it is a lawful order. And the reality is, a lawful order is only a directive issued by a police officer when it is an order or directive that is in compliance with a law. Otherwise, they do not have authority, limited delegated authority, to issue directives to people that do not, Turner versus Driver, Fifth Circuit, yeah, that's for recording. Yeah, they do not have the authority to tell you to do things when that is not inside the boundaries of law. And as an example is your case with Martinez, Rincon versus Martinez, is that just because they tell you to keep moving back, it's not reasonable, and it's not a valid order when it's not backed by law. And if you're not in a position or place where you can interfere with the active investigation or service provision of a public official. So they don't have that authority. And so in James' situation, I'll just say, for what I just saw popping up here, and this is the first time I've seen anything pop up. I don't know how that happened, but kudos to you guys. But the reality is that he's got a rock solid First Amendment violation, and he's going to have a First Amendment retaliation because it's all based on speech. And if you go back to City of Houston versus Hill, that is probably the premier Supreme Court case, which goes back to the late 70s. I think it was decided by the United States Supreme Court in the 80s, early 80s. I'll have to look that up real quick. Wait, I think I have that up right here. Where is it?
That's
there it is.
1987.
1987. Yeah, and he was down the street cursing them out, and it said they made it. Yeah, the City of Houston had a stupid policy. Where am I here? they had a city ordinance that said that you couldn't say anything to the police while they were conducting a traffic stop or anything like that. That would be considered interference. And a lot of cities did this, and it was ruled as being overbroad as an applied, and the Supreme Court issued an injunction to put an end into it, and the city council had to rule, and not city, yeah, I think the city council, they had to eliminate that ordinance because it was unconstitutional as applied and on its face, and so they had to get rid of it. I'm a Persian Gulf War that I want to thank you for what you do, or is it? What? He was at a police station. He said he would give them footage from his camera, but they got a warrant. Is this James Freeman?
Yeah, they somehow
I need to watch that.
Somehow got a warrant for his footage. He had a camera and he had a live stream going on, which doesn't save anything to the phone. They still got a warrant for the phone.
Well, they have to prove before they get a warrant. See, this is what I would do is I would look at the affidavit or the application for warrant. Oklahoma Outlaw says hi to Corners News. What's up, homie? From Ismail. Anyway, but the reality is you have to look at the application for warrant, because on the face of the application, so let me give you some insight here. There is the warrant, and the warrant has to be a document that is signed by a judge, okay, or a magistrate. Now, attached to that warrant must be a separate page, which is called the affidavit or the application for warrant. Right. And that application has to be under oath, sworn, that what is testified within that application is true and correct to the best of their knowledge. And within that application, which means I like to do this, the four corners of that application, it must contain the factual elements of probable cause of a crime. It cannot be inferred. You cannot look outside these four corners for anything. You can't infer anything. You can't have a hunch, or what I like to tell the cops, hump. Right. You can't have anything like that, have their Quasimodo hump. It actually has to be contained in the application for warrant. Now, if it's not there, and this is the problem with a lot of judges, a lot of these judges are really lazy, they're ignorant, and they don't read the applications for warrant. And they just said, oh, you made an application for warrant to review this. They look at it and go, okay, sign it. That's it.
They just sign anything.
They do. They don't read anything. It's horrific. It is actually what I would say. It's an epidemic. It's a pandemic amongst judicial officers because they don't actually read the applications.
And the Fourth Amendment, I think it's very clear. It says a search warrant will describe with particularity the place to be searched and things to be seized.
Right. The items or persons to be seized. But in that sworn oath, it has to be sworn. And remember, when you actually look at every state has provisions for this. And in the Federal Rules of Criminal Procedure, they have rules for how a warrant is supposed to be, what they call the form and content of the warrant. It has to be presented a certain way. And so if they have that, they want footage showing, you know what, I want to see the footage that he told the cop to shut up. Because I would say, F you and your horse, and there's nothing he could do. It's constitutionally protected. Because the cops are supposed to have thicker skin than that. You show me where it says, yeah, okay, well, you know what? There are situations where you can actually sue judges. If judges do not have subject matter jurisdiction to do certain tasks that they're supposed to do, their official capacity, you can sue a judge. You can sue a prosecuting attorney. You can sue them all. They like to think that they have
Prosecutorial immunity.
Prosecutorial immunity, or judges have absolute immunity, and the reality is that they do not. So yeah, isn't it fruit from the poisonous tree? Because well, okay, remember this, is that the fruit of the poisonous tree would have to demonstrate that the actual evidence is contraband or proof of a crime, and it would be therefore inadmissible. Okay, so let's say you're walking around with a backpack and you had 50 pounds of weed in it, and you're walking across the park, and the cops see you sell something, and they grab your backpack and open it up and see that you have 50 pounds of weed, and they basically searched you without a warrant. Okay, under certain circumstances, they can say, well, I think that's Murphy versus US is similar to that. You gave them consent? Is that what you're trying to say there, Oklahoma outlaw? No,
I believe he did, but they already, when they came out, they had already signed, or they had an approved warrant already.
okay, well, we can look at the timing of that. But the reality is that simple statement of shut up or F you or any one of a number of things that show disagreement or disapproval of the police outside of threats of violence, no, constitutionally protected. And where they can have, they took their phone for evidence of what? I've looked at a lot of cases that involve the seizure of a camera, and the only time they can keep the camera, this is the truth, is if that camera was believed to be used in the commission of a crime. And they can't keep it if it's in REM. Oh, say, yeah, they can download information off there, same thing with computers, but they're not supposed to keep them forever unless they believe that they are purchased from the fruits of crime. Okay, that's one example. Like you use drug money to buy a computer, or if you use drug money to buy weapons, or if you use drug money to buy phones, then they can keep it because it is evidence. It's called fruit of the crime. Okay, well, no, there's another word for it. It's called, anyway, it'll come to me. I just had it.
So that they seize those, and they have a special account for that. I forgot what that, like when they seize money and stuff.
Yeah, it's called well, it's fruit of crime. It's the fruits of the crime. Oh God, it's right there on the tip of my tongue. But anyway, we'll just keep talking about it. But so yeah, if it's the benefits or proceeds of a crime or benefits of a crime, then they can seize it and they can get a warrant to search things, something like that. But in this particular case, now, did this happen in Arizona or New Mexico?
No, this happened here in Texas, McKinney.
In Texas? Where?
McKinney, Texas.
Oh, down, is that
north?
Up by Dallas?
Yeah, a couple hours north.
Oh, farther north. Okay, I'm going to tell you this. There's a lot of these backwoods police officers or police stations that these people are absolutely uneducated. And you and I both know, Ismael, that thank you for that. Can we tag that? Okay, just send a text over however we get it. Ismael has it, so I'm going to take that. I'll watch the video. But yeah, McKinney, Texas, yeah, that's we've seen so many different situations where people are video recording the police in these small towns, or like what Jeff Gray has done around the country. Honor your oath. He goes out there with that little sign that said, "God bless the homeless vets" on the backside. It says "Pray for our homeless vets" or something, whatever he does.
Or
and he honor your oath.
No, Otto the Watchdog. He's another guy from Texas. He made a sign that says, "God bless the homeless," without an M. The homeless vets.
God bless the homeless vets. Well, yeah, I would say I would agree with that. But there's a case that was just recently decided. I think it was down in Georgia, where a guy was driving around with a flag in the back of his truck that said F the police or something like that, and they pulled him over, cited him, arrested him, impounded his truck. Anyway, they ended up losing the case because it was constitutionally protected. And a lot of these cops say, "Oh, this is how stupid they are." I mean, they are so, you guys, I mean, if you do anything like this, you are so incredibly stupid. You know, just because you don't like it and because there's kids around. What is he? And then what, Fred? And he did was say, "Shut up," and they arrested him. Okay, it's a clear concept. Well, let me back up and say one thing here about this, because we want to continue with the podcast as we're going. In many situations, we'll talk about, say, no, they can't do that because it's illegal. No, we'll say that it's illegal if they do that, but they do break the law. Remember, you're dealing with low IQ knuckle draggers that can't think for themselves. They're directed by their superiors who are not much better. Excuse me just a quick sec here. Yeah. Okay. Sorry. Just making sure that I don't have any emergencies here. Okay. All right. So let's go back to where so what I'm saying is that a lot of people say, "Oh, they did this, they did that, or they can't do this." They shouldn't do it, but there's many scenarios where these people just break the law. And so what you do is when they do that, then you deal with the criminal issue. And as you know, Ismail, you've done this a bunch of times. You start attacking the foundation of the case, and you don't wait till the last minute. You immediately start attacking the foundation. And so in this case, okay, he's been arrested. I'm sorry to hear it. It's obviously an abuse of the discretion of the police. And I would start setting things up to have a Monell claim against the McKinney Police Department and sue the shit out of them. So he got arrested for saying "shut up." Oh, why? Did it hurt your feelings? Is saying "shut up" to somebody? Here's the question: is saying "shut up" an assault or an assault and battery? No, absolutely not.
Yeah.
So what did they arrest him for? For saying "shut up"? It's not going to stick. It's obviously First Amendment retaliation. Somebody had a chip on their shoulder and they didn't like the fact that he said that. And so this is why I encourage people to learn how and follow through with civil rights lawsuits against any public official that infringes upon their constitutional guarantees, period. And it's a little work, but remember, you are an assistant attorney general, a private assistant attorney general. And you need to do that because you're doing this for the benefit of everybody else. We're tired of this. We're tired of this abuse, these false arrests, and they need to be paying heavy punitive damages for that misconduct. Because how many people have been shot and killed? I mean, you know, there's obviously going to be a couple of police officers watching this, and they whine about the cops that get killed every year. You know, and on average, there's like somewhere around 200, but they never talk about these several thousand private citizens that get killed and maimed and abused by their misconduct. You don't hear that. Let's just worry about them. No, I'm not going to worry about them because you work for me. Let's hold you to a higher standard. Why don't you learn how to behave yourself? Why don't you have a cup of shut the hell up and do your damn job? Okay? Just because you don't like somebody, just because you don't, you got a chip on your shoulder and you want to come get them. You know, we the people need to stand together and put an end to the tyranny and the abuses of these public officials. So as far as that goes, no, they shouldn't do it. But did they do it? Obviously they did. They broke the law. That is actually There's two things that can be done. Number one, you got to get the case dismissed. It's going to be easy enough. They aren't going to prosecute this. The second thing is they need to start preparing a civil rights lawsuit. The third thing is start preparing their criminal affidavit for the FBI and show how they violated the acts. And there's several ways they can come after them under a criminal situation under United States Code Title 18 under Section 241. If more than one person was involved in conspiring to violate his rights, if it's outside of a policy, in which case the department can be criminally charged and all the heads. Everybody that was involved in the conspiracy to violate rights and who did can be criminally prosecuted under 241 and Section 242. So that's what you do. What you do is you have to hit so hard, and there has to be so many people that do it, that they're going to finally start waking up, and the insurance companies that cover them, because remember this, anytime you go to a mediation or anything like that, you're going to find out who's sitting in the room with the police officer's attorney. It's going to be the insurance company claims representative.
TML
they're sitting there.
Texas.
Huh?
In Texas, it's TML.
Oh, Texas is TML. Okay. I'm sure there's probably more than one, but there's definitely TML. That's one. I think you mentioned that to me.
Yeah.
So that's who's sitting there, because if they lose the case or there's criminal convictions against the police, the insurance rates go through the roof, especially if you win a Monell claim. The insurance rates. So instead of these people having to pay, the city's paying, which most people don't know about, paying hundreds of dollars per month for every officer they have, it could go up into the thousands. The thousands. And since money is their god, and if you think I'm kidding, why do you think they issue so many bogus citations? Why do you think they make so many bogus arrests? Because it's all about money. It's all about money. How come there's so many false DUIs? Because it's all about money. They get federal funding. The more arrests they get for DUIs, because they're saying, hey, look what good boys and girls we are in our municipality making all these arrests for DUIs. So they get money from the feds for that. But when they find out they're making all these false arrests, then it gets to be a problem. So that's what I can tell you. Anyway, oh, there he is. So getting back to James, and we'll move on. So those are the three things James can do. We're happy to talk with James. They aren't going to keep him for very long. They're going to get him out. And this is one of the things I tell people all the time. When you learn how to start... Okay, good. When you learn to start standing up for yourself, and you can start defending yourself without an attorney, because it's not that hard. If they don't have probable cause, they don't have probable cause. If there was no law violated, there's no law violated. It's not even going to make it to the prosecution. But what I would say is that, yeah, you want to definitely get it to arraignment so you can plead not guilty, because in that second, now you can sue them for a malicious prosecution. That's another cause of action. So you want to get them to start going through all this stuff. And, you want to make them, you want to make it painful for them. Because if money's their god, start taking it away from them. Start make it cost more for them to have a cop in their employ. Because that's not what we voted for. That's not what we hired them for. We hired them to prevent breaches of the peace, not to create unnecessary rights violations against people who have a right to be completely upset with what you're doing. And isn't it funny? We were just talking about a case. Let me see here. Where is it? I just had that up here. In Christopher versus Harbury. I think that's a different case. That's a case for public records. But anyway, in City of Houston versus Hill, which is a standard case, you have the right to criticize the police in the performance of their duties. And if he's 25, 30 feet away and the cop's saying something to him, he can tell him, shut up. Because contempt of cop.
I have done it before.
Yeah. Oh, yeah. Many people have done it. But to target him while he's in the process of video recorded, That's an easy case to prove that was First Amendment retaliation.
Retaliatory. Yeah.
Yeah, and that's easy to prove. And let's see if his supervisors endorse it. I'm going to see if the prosecutor is going to say anything. I mean, I think the prosecutor would be hard pressed to do anything. So anyway, that's that. So First Amendment. Yeah, it's a wonderful thing. And unfortunately, you know, if you put this in a, like I said, take what he said to that cop in a situation where it's a citizen talking to another citizen, and they said, "Shut up." What could you do? Saying "shut up" with nothing more is not a crime. You can't even get them for disorderly conduct. Okay. The bad part of a settlement is that it clears the police department of any wrongdoing, correct? If that's part of the settlement, absolutely true. Unless it's written in the settlement otherwise. I'm going to tell you, I have never seen, although you can't really see these things, but I've never heard of a settlement offer which did not incorporate the no wrongdoing. They're just saying they're mitigating the cost of prosecuting or litigating the case. So it's not a matter of it being written. It's just a matter of accepting the settlement. There is no wrongdoing. It's on Pink Camera Magic. So he was only about 10 feet away. Still, if he wasn't in between whatever they were doing, he wasn't in an unsafe place. There's nothing. Yeah, put it this way. We'll get the facts and let's look at it. I'm happy to play with this too. I'm happy to look at it and, you know, give him some ideas on how and what to draft for his dismissal. It's in Texas. This will be fun. They never really want to prosecute these things. And remember what we talked about before is those are misdemeanor cases. So out of every 1,000 misdemeanors, only 20 make it to trial. Why is that? Why is it that so many people never go to trial? Because they whip out, take a plea deal. Some cases get dismissed, or the prosecution decides they're going to withdraw the cases. But
they sign plea deals because they get public defenders.
Public pretenders.
Yeah.
Now, in fairness, like everything, I've seen a few good public defenders, very few, and I've seen a lot of very bad ones. A lot, by far. Public defenders, yeah, because they don't want you to fight. Nobody wants to go to trial. Because I am telling you, unless you've ever been to a trial, trials are a lot of work. And I'm going to tell you that a prosecuting attorney's office, city or county, does not have the resources to prosecute these cases to trial. Do not. So they try to keep as many as possible out of the courtroom. And I would agree with that. Keep as many out as possible. But most people accept plea deals because they're scared to death.
Yeah. Especially felonies.
Yeah. Felonies.
Yeah.
So anyway, so we'll talk more about James a little bit. We'll look at all this stuff. So he got out. He can do a request for the return of his camera, unless his camera was used to commit the crime, like he beat somebody with that camera, then they could hold it as evidence. But as far as him just using it, outside of the information it could possibly contain, the camera in and of itself is not a sufficient tool of crime. And so they're going to have to give it back. I'm trying to think somebody else that we talked to. Recently, I just helped with that. They refused to give the camera back. And I helped them draft a letter of demand for return of property, listing the statute and case law.
I filed, I have sent a couple of those because they had my firearm.
Okay, yeah. And you
Yeah.
got your property back.
Yeah.
Because they can't because that's a violation of the Fourth and the Fifth Amendments for them to hold your property and deny you access and use of your property without just cause. So these guys are small-minded. It sounds to me like they're about 10, 15 years behind the legal curve. And they do things to be malicious. Like I said, you're dealing with small-minded people. They're very childish. It's unfortunate, but we have them there.
Yeah.
And so anyway, James Freeman, or anybody that knows James Freeman, if you'd like a little contact or a little help, let me know. I think it'd be a lot of fun. Yeah, a lot of people, yeah, they'll accept a plea deal because they don't have the funding to go to trial. But the reality is there is not a case. That's what I'm going to tell you. I've looked at hundreds and hundreds and hundreds and hundreds and hundreds of cases, criminal cases. And I have found very few that were valid. Very few that had, for the arrests and the charges, that had probable cause. A lot of encounters never had reasonable articulable suspicion. And people get afraid. I'm going to tell you, that's the number one thing. People get afraid. And a lot of attorneys know this. And when you go talk to them, they're going to base their fee structure sometimes, not always, but they'll base their fee on your fear and what you are charged with. Even so, if it's something ridiculous. And I'm going to say it like this: if you think I'm just joshing here, just pulling your leg, I talked to Ismael pretty in depth and extensively and in depth about his, was that a third-degree felony charge with the tow truck driver?
Uh,
Had to be, because his attempted, was it assault with a deadly weapon?
aggravated assault with a deadly weapon. Yeah.
That's got to be a second or third degree felony. And the case was dismissed because there was no probable cause to ever justify the arrest or the charge or anything. There was no sworn statement from anybody. And the prosecutor sat on her fat ass for months, almost a year, and refused to look at the video that exonerated him. Refused. She didn't stand a ghost chance in hell of prevailing in that case and getting a, what we like to say, she did not have reasonable belief that she could hope for a valid conviction. She should have dismissed that case a whole lot sooner. And instead, she drags it on. Huh?
Second degree felony.
Second degree felony, yeah. So that's what I'm saying. And absolutely, when you're innocent, don't take a plea deal. You fight it because you want to sue them and hold them accountable.
Yeah.
So in James' case, they're going to probably drum up some other stupid charges. But again, get through the arraignment. If you want to sue them for a malicious prosecution in Texas, it's under the Fourth Amendment. Yeah, go ahead and go to arraignment. But okay, now let's get back on track here. Okay, let's get back on track. So we're going to talk about the First Amendment. And as we're going through this, we want to get to the point here where we're talking about redressing your grievances against the government. And part of your redressing your grievances against the government is being able to get public records. Now, if it's federal, it's called FOIA, Freedom of Information Act. And each state is different. Some have a Sunshine Act. Some have what's called the Information of Public Records. Some of them have, like, let's see, Texas has the Public Information Act.
Texas Public Information Act.
Yeah.
New York has a FOIL, Freedom of Information Law.
Okay. Yeah, every state has something. And that's because the Constitution, we the people who drafted the Constitution through our representatives, wanted to have this in there. We wanted to have safeguards for the people. Now, from there, in petitioning the government for a redress, that means we're entitled to information. and they can't withhold it from us generally. So in Texas, let's go to the next one here. Okay, under what is this? Under Texas Government Code, which is actually the step down from the further codification and clarification of the Constitution of the state of Texas. 552001 policy construction. Under the fundamental philosophy of the American constitutional form of representative government that adheres to the principle that government is the servant and not the master of the people, it is the policy of this state that each person is entitled, unless otherwise expressly provided by law, at all times to complete information about the affairs of government and the official acts of public officials and employees. This includes their personnel files, by the way. The people in delegating authority, notice it doesn't say they have authority. The people, like I've said before, delegate limited authority to these public officials. Excuse me. Do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments that they have created. And who are those instruments? The institutions and the people that serve in a public or official capacity. The provisions of this chapter shall be liberally construed to implement this policy. This chapter shall be liberally construed in favor of granting a response for information. Don't you like that word liberally, which means they cannot make it so narrow and difficult to get information that you have to use special magic words, that you have to do everything in a certain and specific way that's so tightly controlled that it may prohibit and prevent some people from actually accessing this information. That's why I love that there, man. Texas did a great job. So our instruments of government are required to provide information to us unless it's to be protected. And it's clarified in here why it should be protected. Now, notice this is a policy, not a statute, but it is a policy for how public information should be controlled and directed. Now, when we get into public information requests, then we get into the practices of what's supposed to be done. So, Ismail, go ahead and pull up one of yours here. And go ahead and read it.
Let me make it big because my eyesight is not. All right, it says this is for the citywide, the city of Rio Bravo, and then you add the address. If you don't know the name.
Okay, hold on a second. Hold it. When you talk about issuing a public records request, we need to talk about who it's directed to. So it's whatever
Correct.
agency or group it is, City of Rio Bravo, to the custodian of records. And that's
Correct.
who it's going to be directed to. Every department, agency, or office has somebody designated, regardless of their job title, as being responsible for the records, and they are therefore classified as the custodian of records. So all the public information requests should follow this kind of pattern. Gives the address, and it says greetings. Go ahead and continue.
Yeah, and the what you were saying about the custodian of records, every agency, every government body has to go, or somebody from that government body has to go through a training with the Attorney General, and that they have to go through the Public Information Act training. And
Yes.
I have also requested those certificates, and they have to go to Austin and take an actual training. So
Yeah,
every
to
government
Austin,
body
right?
in Austin, yes, every government body has to have a custodian of records, regardless of their position. Sometimes it's a mayor, sometimes it's a city council member, city secretary. Uh, so yeah, and then the address. Then it says, "Greetings. This public information request is being made to your office, department, or agency specific to the Texas Government Code, Title 5, Subtitle A, Chapter 552." And then C, attached. In accordance with said code, I am requesting. Then that's where you add what you're actually requesting. In this instance, I requested screenshots of bank transactions and receipts for cash transactions under Mayor Gilbert Aguilar's term, and so on and so forth. After that, as you are aware, the Texas Public Information Act shall be liberally construed. That's what Fred was reading earlier. In favor of granting a request for information, and that you promptly produce. So if they have it available right there, they can give it to you. You don't have to wait the full 10 days, which is in Texas they have 10 days to respond. But if they have it ready, they can promptly produce it. If you expect significant delay in responding to this request, please contact me with information about when I might expect my copies of the requested information. And they should respond to this. They should let you know before the 10th day. So let's say they need more time. They should contact you on or before the 10th day that they need more time, or whatever the case may be. Or if they going to request a decision, which is the next part here. If the city of Rio Bravo wishes to withhold information from me, you must seek an attorney general decision within 10 business days of your receipt from this request, and state the exceptions to disclosure that said office or agency believes are applicable. Be advised that your office or this designee must also send me a copy of said letter to the attorney general within 10 business days to receive this request. So what that means, whatever they say to the attorney general, whatever they're claiming to the attorney general, they should send you the exact copy to you as well.
Yeah. So in other words, there's no mystery here. Can you still hear me okay?
Yeah.
Okay. So those last two paragraphs that are involved in this letter are actually taken directly from the Texas Government Code. And that gives them directives on how they're supposed to conduct themselves when a public request is made, a public records request is made. So they can't just sit there and willy-nilly around and take forever to get it to you. Texas does a great job because they say, you have 10 days to respond and get that out to them from the date you receive the request. And if you don't want to, well, first of all, if it's going to take more time, you have to let them know it's going to take more time and why. The custodian record has a duty and obligation to send a letter as to why it's going to be taking so much longer if they can't get it to you within 10 days. And then that same letter, they have to tell you when they expect to get it to you and comply with that. Now, if they're going to challenge your request, which is what he's saying, and I'm just paraphrasing here, it says in the code, because so you know that we didn't make this shit up, it says in the government code that if you're going to take exception to our request or any portion of the request and ask for an attorney general, so it tells them what they have to do if they don't want to give it to you, then they have to make a request for an opinion from the attorney general in the state of Texas. And they have to write a letter and they have to attach, these are the procedures, like I said, procedures like making a cake. They have to take their letter that they're saying what they don't want to give you, attach a copy of your request. They have to send it to the attorney general. And in their letter, they have to say exactly why they don't want to give you what information. And it can get kind of hairy. I mean, we've won a few. I think I've been involved with probably in the state of Texas, probably maybe 100 to 150 public records requests. And I think we've probably lost 5, maybe 6 out of all those, where the state attorney general said that, well, in our opinion, they don't have to give you that information. But if you know the law, which we believe we do, remember it's a Texas state attorney general opinion. And in their opinion, they will make reference to state law, state appellate court rulings, and say
Right.
why they shouldn't have to or why they have to. And if you disagree with what they rule, you actually can sue and have a judge evaluate it and make a determination, because it's only an opinion. But most of the time, most people don't take the time with it. It's public information, so let's not make it a big deal.
Right. Most people don't fight through a public information request. Also, it would be smart to, every time you file one, get a stamped copy. If you see this one at the very left bottom corner, it has a date, 22nd November 1, and then the time and a signature from the person that received it. So
Okay,
that's always
that's
important.
perfect. Or you can do certified mail return receipt requested if you want to do that. Or a
Right.
lot of people like to remain anonymous, and they can make that request
Anonymous.
similar to
Yeah.
this and just say, I will come pick it up in 10 days.
Right.
And you can do the
So-
same thing.
So this is an example of sending a request through certified mail. Right here. So this one was sent. If you notice, there's no stamp date, but I attached the receipt. And
On
then,
the certified mail. Mhm.
right. And then this is when they received it. Your item
Yeah.
was delivered to an individual at the address at 2:20 p.m. December 5th, 2022.
Yeah.
So, I mean, it's always smart to have a federal witness, right, Fred?
Yeah. Always smart. I'll tell you what, I like to have, and mail is pretty interesting because even when they consider service of certain documents through the court system, they say that regular mail, first class mail, is considered effective and valid service. Who trusts the postal service? My gosh. But anyway, when it's certified mail, return receipt requested, and it's worth paying for that. You actually have, like Ismail said, you actually have a witness demonstrated everything was done. It's credible and valid within a court when you demonstrate you conducted some kind of business and issued mail a certain way and somebody received it. Then they can't say, but I didn't get it. You won't believe when you get into legal issues
Oh, yeah.
how many people say, I never got it. And the government is the worst. They're the worst because they don't want to be accountable for anything. They all want authority to push people around and do whatever they want, but they don't want the responsibility to be held accountable when they F up, and they don't want liability for that F up, which is, we can have a whole conversation on that another day. But anyway, so here's the public records request, how you track it and document it to make sure that it's something you can use through up to and including in court.
Yeah. And actually, this is a letter received from the Attorney General, because in this instance, these 3 public information requests, they did not produce anything. They basically ignored the every single request.
And as I understand, isn't that kind of been the standard for the city of Rio Bravo? It's been an ongoing problem with them that they don't honor this.
That's why I went through so many steps in making sure everything was documented, the date stamp, and including video recording of me personally delivering the request. After the refusal, I filed a complaint in the Attorney General's office, and they responded,
Nice.
and and they ordered them to release everything, which is this letter right here.
Which, when it comes to public records in the state of Texas, I think the state attorney general has the authority to direct them to release records. And we've gotten a bunch of those because they didn't want to release information because it was incriminating for misconduct and relevant to Monell claims. When I say Monell, which means liability for a practice, custom, or policy of a city office or agency for violating people's rights. Now, in this situation, which we'll talk about, he's going to go through this here. This is Ken Paxton's response, is whoever signed it told them to release the information. If they don't, and even if they don't, they still have a practice of violating people's First Amendment rights to have access to this information, and you can sue them in a Monell claim in federal court under United States Code Title Section 1983, Title 42, Section 1983, because they just don't want to give you the paperwork, the public records, and they just don't give a crap. So then you can sue them, and you get a couple things happen.
And what would be I'm sorry, what would be the cause of action?
First Amendment violation.
Right.
They have a custom or practice or policy. And it would be unlikely they have a written policy, but with so many letters, you've already established a Monell claim. But the statute of limitations is only 2 years. Oh, it just expired. Well, no, if they failed to act, no, you still have the cause of action.
Yeah, they failed to act. This letter was just sent. This is a second letter dated September 18, 2025, which is reordering them to release a document, which they released some information only because I sued them in district court.
Okay. Then what you can do, which we talked about earlier, is that you can actually, well, I'd have to see what it is in Texas, but you can file a notice or motion in the court to that you did not get all the information, and motion the court to find them in contempt of court. And the court will again order them and find them in contempt and fine them or sanction them in whatever way they choose. But then again, you still have proof. I mean, it's so clear that they have a blatant policy or practice of violating your First Amendment right to have access to this information.
Yeah.
It's blatant. That's a clear win. That's a clear win. So,
yeah.
And I'll tell people that are listening, remember, it's not always about money when you sue these when you go to court on these cases. It's about justice. We want our government to behave properly. And so we use the mechanisms that are available to us, which include, under the redress of grievances, civil rights lawsuits under Title 42, Section 1983. Okay, so I hope that helps a little bit. We've been on here for almost an hour, haven't we?
An hour, yeah.
Okay. Wow. You nailed it, Ismael. Hit it out of the park. You hit it out of the park.
Yeah, I think that many people don't concentrate too much on public information requests, and it's kind of complex, but not really. Once you,
I think if you take that letter and use it as a template, it's easy to ask for things. Remember, a request for public records must be liberally. So they don't have to make it so narrow. You don't use magic language or anything like that. It has to be liberally construed. And those records need to be made available. So everybody should do it. I would even do this as if you want to practice on one, and it's fun. And you don't have to do it certified mail, return receipt requested. You can actually just take it down to an office and ask for the salaries the names of everybody in the department and their salaries, their job title salaries. I want the name of everybody that works in the public works department, and I want their salaries and how long they've been employed.
Yeah,
And guess what? They have to make that available.
Yeah, I have won so many opinions that they request, including the district attorney's office, custodian of records, and I believe they committed a violation on one of the latest requests. I requested the front lobby, the public lobby, security camera footage. They requested an opinion, and they said that they had to release it. And when I asked them for the information, they're like, "Oh, we no longer have it because time expired on the system, and it's no longer
Okay.
saved."
Now, here's what I would do. Then I would file a public records request for their policies and procedures relating to when they set up the cameras, how long they hold the footage, when it's being recorded, who's in charge of it. I want a name. I want a name because I want to nail that MFer to the wall.
The thing is, when you request the information and you believe that that's you can withhold that information, you should automatically send that information to the AG. That's how I understand the act, the Public Information Act, because they're supposed to send the Attorney General what you believe is the statute regarding the withholding and what the exact information you want to withhold. So in this instance, they should have sent a copy of the video and tell them this is what we don't want to release or what we believe is what's the information we don't want to release. But they didn't preserve. That's the word I was looking for. I'm sorry. They have to preserve that information being requested, and they didn't.
Yeah, and if it involves any kind of a civil or criminal action, it has to be preserved as evidence up until 2 years after a Supreme Court ruling. So a lot of these people think, this is what I'm saying about these public officials, these public servants, these bugs. They are so afraid of liability that they'll lie, cheat, and steal to make sure that they're not held accountable and be liable for their misconduct. And that's how we get into a place where we're entering the world of communism. And these people, I'll tell you what, as long as they save their ass, they don't care. That's just the way they are. They're just, like I said before, everybody wants authority to be able to tell people to do what to do and do what they want. But they don't necessarily want responsibility for what they did. And they don't want to be accountable for it. And they definitely don't want liability for when they F up. But that's the whole point. That's the whole point of the laws and the statutes and the guidelines we have through the amendments. These people are accountable and liable for their conduct. And you can't have communist judges in there ruling on their cases because instead of holding them to the higher standard that we, the people, demand, they hold them to a, substandard sucker standard, the good old boy standard. But anyway, we'll save that for another day.
Yeah.
Anyway, you did awesome, Ismael.
No, you did awesome. Thanks for it.
You did awesome.
Thanks for being here with me again, and thanks everyone for staying here. There's a bunch of comments here. We'll go over them.
Yeah, let's go. If they don't mind, let's take 5 minutes and we'll go over a few comments. Anything worthwhile.
Okay. Says...
And again, anybody who can get a hold of James Freeman, tell him he's got people that want to help him out. See, on the plea deals, you basically give up all rights to appeal. When you make a plea deal, to face your accusers, evidence, everything like that. When you make a plea deal, it's an admission of guilt. The case is over. So When you make a plea deal, I plead guilty. What you did is they said, we're going to present an offer to you for you to plead guilty to this. Now you are no longer saying nolo contendere. You're not saying not guilty. You're saying I plead guilty, and therefore you waived. Let me do that again. Waived all rights
What if
to a defense.
what if the person or the defendant was maybe intimidated or coerced or threatened
That's
or
very common. Okay, now it's tough to win, but you can win that. You first address the judge in the case and let him know that you were pressured or coerced, or the plea acceptance was not voluntary, because the judge will ask you that in open court. Just say, this is a plea deal. You pled guilty to this, this, and this, whatever it is. Did you make that plea voluntarily? Did you understand what rights you were waiving when you made this plea? You waived the right to this, jury trial, everything like that. When you make that plea of guilty, you waived all those rights. But if you were pressured into it, and I'm gonna tell you this, I think everybody should know this. I have sat in on meetings and been exposed to meetings and aware of meetings where somebody's own public defender or their own paid for attorney was forcing them. I mean, well, I shouldn't say forcing, because how do you force someone? But they were doing everything they can to convince them to accept the plea deal, yelling at them, belittling them, humiliating them. Even why the prosecution was on the other line and in front of their family doing, I was like going, what the heck? I said, if they're working so hard for you to take that plea deal, definitely say no. I'll take my chances at trial. The only time you do this if you're, and no judge signed an order to repo the car. Okay, if we're getting into car repossessions, I'll tell you, I want to talk about that sometime, because that's a self-help remedy, and in the state of Texas, it's under the Business and Commerce Code, and it's also involved in several other areas, which Ismael is now aware of. And it is not, unless they have a signed order by a judge, they cannot take the car under certain conditions. But they allow them to be sneaky. The law allows them to be sneaky. If your car is out in public and they're following you, they can hook up your car and take it if you're not in it. If they come onto your property and you don't have no trespassing signs, they can take your car. And
Yeah.
remember this is a civil matter, not a criminal matter. And we'll talk more about that later on. So if Wade, if you want to talk more about repos, we've won tons of repos. We actually shut down repossessions in the state of Hawaii, because we told people, man, unless they have an order by a court, they can't take it from you if you tell them to get off your property and get away from you. Cannot, because it's a breach of the peace, and the police have a duty to intervene and get them away from you and your vehicle. But again, cops have not been properly trained and don't know this. So we've had to sue them a few times for this, help people sue them.
Yeah.
So anyway, no, you're never going to see a judge's order on a car repossession.
Yeah.
So if you see another one, you can pop that up. But anyway, we have a great system of law in this country. We have a great system of justice, but I will say that it has been heavily abused by people that are incompetent. And it's not just the people who are the public servants, it's everybody. And as far as government official goes, it goes up to the people that are in the Congress, in the Senate, state and federal, peace officers, FBI, everybody. They just, because we're not taught it, and it doesn't take a lot of time, but when you learn how simple the foundations of law are, you can look at any situation and just on gut instinct, you can say whether or not that's constitutionally compliant or not. And you can say whether or not they violated somebody's rights or not. But the whole point of the court system is to slice and dice it to make sure that we have a better and clearer understanding of it. But as long as you don't infringe on somebody else's rights, you're pretty much good. But anyway, go ahead. You got another one?
No, I don't have another one.
Good, because I wasn't going to answer another one. Anyway, I think we're about done here, ladies and gentlemen, and those that'll see this and follow up on this. Get in the habit of writing a public records request. Encourage your kids, help your kids write one. Teach them how the government works for them. They are the servants. And that's what I love about that attachment that we use for the ones in Texas, about how they are the fictions that we create. Can you negotiate terms even with a plea of guilty, but don't put on record or traffic guilty with no points on a record? On a traffic citation, now, okay, understand on most traffic citations, they are not civil, they are not criminal, they are administrative. And that's why you do not generally go before a real judge.
Unless
you can negotiate that. Go ahead.
Unless you appeal it.
Yeah, you can appeal it after any ruling, but if you make a plea on it, you still can negotiate it. Not after the fact. After the fact, you can't do it because it's a done deal.
Right.
Everything you do that you negotiate, you have to negotiate before the final agreement, and that's what a plea deal is. A plea is an agreement. So, anyway.
Right.
All right. We will see you guys next Thursday. I think. I hope any of the things that we're talking about are a little helpful. I kind of have to apologize for last week, man. I was so dog tired, man, and I had cotton mouth. I had to keep drinking water. But if you're paying attention and learning, you're going to find out that you have more power in your pinky than the entire United States government, as long as you're standing on the right side of the people. Not the government, the people. Welcome, Wade. And anyway, let James Freeman know that he's got heavy hands waiting to help him out if he's interested. Because I'm always up for a good ass whipping against the people that do wrong. Always up for it. Oh, the Mueller Commission, yeah. Yeah, the Mueller Commission, that was great. That was really, really good. So a lot out there. Well, I appreciate the comments and the thoughts and the questions. And for next time, if you guys have any questions that you want to bring up or comments, bring them up. When we're starting at the beginning part, I think we might leave open like 5-10 minutes to see what's on people's mind and maybe address them, and then we'll go over something else. Next week, I think we might talk about maybe a little bit about the Fourth Amendment. The Fourth Amendment is huge. First, Fourth, Fifth, Sixth, is not as big as them, and they'd never like to use the 14th, or the 8th. They don't like the people using those. But I'll tell you what, we'll talk about them and give you some more insights. And remember, there's a whole library of information about these cases and situations. My new addiction is depositions. Yeah, if you know how to do a good deposition, depositions are a lot of fun. And the primary reason you would ever do a deposition is only to impeach your witness at the time of trial. Just tell you that. And yeah, I like depositions. Depositions are fun because most of these people have never been deposed in a civil rights action, let alone criminal. Well, you can't do it in criminal, but in civil rights action. But most of them never testify in a real criminal case. Because there's information that'll come out to find out that they broke the law, which is what I've found in many, many cases. But anyway, God bless everybody. God bless America. God bless Ismael and his family.
Thank you.
And you guys keep the truth, keep the faith, man. Stand tall. Get up off your knees, stand tall. And make us all proud. We are Americans. We are brothers in this country. We are the ones that stand for righteousness. So stand with us. Let's make America great again.
All right. Thanks for watching, everyone. We'll catch you on the next one, next Thursday. Thank you.